Welcome to the Bulwark podcast. I'm Charlie Sykes. It's Thursday, which means that tonight we have the exclusive Bulwark Plus live stream. The whole team gets together and we talk about the news of the day and the news of the week. If you have not yet signed up for Bulwark Plus, you have an opportunity to do so. If you are one of our members, thank you once again. And just remember that we will be doing this at 8 o'clock Eastern time. If you miss it, we do post it. We post it as a podcast and as a video. So obviously, we'd like you to join us live, but that's actually not required. There's so much going on. By the way, if you haven't checked out the homepage today, two really remarkable stories. Number one by Olivia Troy, how the GOP absorbed far-right extremists. What started as campaign rhetoric became government policy, and for a few days, a congressional caucus. Really strong essay. And the lead today is by our publisher, Sarah Longwell. Did we forget our democracy is still under threat? Our guest today is Kim Wehle, who is a contributor to the Bulwark. First of all, Kim, thanks for coming back. I appreciate it.
Oh, I always enjoy it, Charlie. Thanks for having me.
Well, it's funny. I actually woke up this morning before I opened up my phone to see what was leading the Bulwark, which is always a surprise to me. And I'm thinking, it's so weird how we have, how remote January 6th seems right now, that we're not doing anything about it, that it just seems like, we've talked about it being memory hold, but for some reason it hit me that we had this insurrection inspired by the sitting president of the United States, aimed at stopping the counting of the electoral vote. And we're, 3 months out, and it's almost like it didn't happen. And even though the president was impeached and you had 7 United Republican senators voting to convict him, the Republican Party is still making the pilgrimages down to Mar-a-Lago and kissing the ring and other things. And it's bizarre. So when I opened it up and I saw Sarah Longwell's piece, did we forget that our democracy is still under threat? I think this is exactly what I was thinking. That even though the coup failed, it doesn't mean that the threat is over by any means, is it, Kim?
No. And as you know, I've been sort of talking about this now for many years, that democracy's hanging on by a thread. And a few years ago, it seemed like hyperbole. January 6th happened, and friends said, Kim, you talked about this years ago. I thought you were a little off the deep end, but now it was even worse than you anticipated. And frankly, Charlie, I feel like it's been more blatant in terms of the attacks on democracy since January 6th, that the whole the sort of yard line has shifted, where we're seeing, and I know we'll talk about this, blatant attacks on voting rights, blatant attacks on First Amendment rights, lies, soup to nuts, that clearly the Republicans have decided that their way of sticking with minority rule is not to persuade the hearts and minds of people through legitimate policies, but to silence people, to use the racist tropes. And frankly, the Democrats, I'm not sure what they're up to either, because the last I checked, it's like, what happened to the 9/11 style commission for January 6th? And it's like, oh, well, the Republicans want to talk about Antifa if we do that. That's so scary. I don't understand this. I thought this would be top of the agenda. Listen, we've got to figure out what happened on January 6th. I don't understand it, Charlie. I don't understand it.
Well, the Republicans made a very conscious decision not to let Benghazi go. You might recall that. You remember how many hearings
11.
they had? It went on and on and on and on, and they fixed on it like a limpet. And the contrast between the Democrats going, we just can't do it, we have other things on the agenda. It is unfortunate, because in terms of the impact on our democracy, every once in a while I get people feedback from folks who say, why do you keep focusing on the people on the extremes? Why do you amplify the things that they're saying? Why don't we treat them like they're completely irrelevant? It's, for example, the America First Anglo-Saxon Caucus, or the people at various publications that are really, spinning new theories about why we shouldn't actually support democracy. And the answer is because we've seen over and over again how those strange, extreme ideas do seep into the mainstream, that you think they're, it's the drunk at the end of the bar. And we've lived through this. I've lived through this, watching how these crackpot ideas become, more widely accepted and then amplified by people like Fox News, the Tucker Carlsons of the world. And I think we're living through this right now. And the Republican Party's inability or unwillingness, or maybe cynical willingness, to embrace many of these extreme ideas. I think you're absolutely right. That all seems to be accelerating. So, the craziest ideas out there, you don't need Donald Trump anymore to advance them. The party is doing that on its own. I mean, that's what's really remarkable about where we're at.
I there's a book by Stephen Levitsky and Daniel Ziblatt called "How Democracies Die." Two professors, and then I've assigned it in my classes over the years. There are 4 pillars of democracy, or I should say, elements that they identify as telltale signs of functioning democracies falling into something other than that, which in my mind is the Republican platform. It's not a platform for actual democracy. They say rejection of the democratic rules of the game is number 1. So, you're starting to erode things like voting by we the people. 2, denial of the legitimacy of any political opposition. Every legitimate point of view on the other side is wrong, is attacked. Number 3, encouragement or tolerance of violence, January 6th. And then prior to that, 4 years of Donald Trump stoking violence. And last is readiness to curtail civil liberties of opponents, including the media, to demonize the media. And time after time, historically, Charlie, there have been functioning democracies that have died. And the notion that somehow American democracy is immunized from that by virtue of our birthright is just wrong. We are slipping into something else, and it is terrifying. And we need to have that conversation.
I should have brought it with me, because I started reading a book last night about the 1850s. Because it's come up so often on this podcast and our discussions that our time, in terms of historical parallels, the decade leading up to the American Civil War. And there's a great book, and I will post it later for people who are going to email me about this. It's about the fight. I think it's called The War Before the War, and it's about the fight over the Fugitive Slave Acts. And then the controversy and how that drove the country, further apart. And there is a discussion in that book, very explicitly linking it to our current time, how when you completely delegitimize your opponents, when the debates become, cross certain lines, then you have reached that point of no return. And it is hitting me that we are at a point now where it's hard to see a resolution. And I'm certainly not saying we're going to have a civil war, but I was thinking about all of that. So I'm just, again, on all of this, and why the real danger here. And let me quote from Olivia Troy's article, because I want to get into some of the things that are happening today. But she writes, and I think this is really powerful, the danger, and you can find this in the Bulwark this morning. The danger of the modern Republican Party is not that it is populist and has nutty ideas about free trade and can't spell. It is not that it favors lib-owning cultural warfare over policy and good government. It is not that Trump is a moral Lilliputian and every other significant member of the Republican Party, with a handful of exceptions, is either a sociopath or a weakling. The danger is that just as the big lie about election fraud became de rigueur for Republican politicians after the election, explicit white nationalism may become the central motivating principle for much of the party. Paul Gosar spoke at a white nationalist conference immediately before addressing CPAC. Senator Ron Johnson has begun dabbling in so-called replacement theory, the same theory that led the Charlottesville marchers to chant "Jews will not replace us." Tucker Carlson recently invoked replacement theory on his show. And as we saw on January 6th, the party is willing to incite violence when it feels like its hold on power is threatened. So she warns the America Firsters, that Anglo-Saxon caucus, which kind of imploded over the last few days, they will be back. They will be better organized. They will have more followers. They will be better armed. What are we going to do about it? And I said, whoa, that's If that's not an antidote to complacency, I don't know what is.
Well, and you just tick through the 4 elements I mentioned. I mean, check,
Yeah.
check, 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 and they talk about in the book that there's not a time in American history then all 4 have been so strongly present as right now. The metaphor I like to use is imagining, the Constitution like a bridge over a very violent river. I think what people don't understand is if the bridge is the Constitution, we can fight over who's directing traffic, Team Red or Team Blue. But if the bridge goes down, we all go down. And I think one of the problems or the mistakes or myths of thinking about this is to adhere to it as some kind of partisan team mentality. If democracy fails, it's bad for Americans. It's bad for Trump supporters. It's bad for Republicans. It's bad for everybody. That is a really dark, dark phase that I think no one should want to go to. But we're so mired in this team win lose mentality that we're losing the bigger picture, and it is quite dangerous, Charlie.
So before we get into all of this, I don't know whether you've seen this long deep dive in the New York Times Magazine about Liz Cheney, but there's just one thing that jumped out. Have you seen this? It's really good stuff.
Yeah, I saw clips of it. Yeah.
Yeah, this is what's great. And it's by Don Draper, and there's one passage that I really liked. Lloyd Smucker of Pennsylvania accused Cheney of having a low EQ or emotional quotient. On his way out the door, one congressman remarked, quote, "I just got to spend 4 hours listening to a bunch of men complain to a woman that she doesn't take their emotions into account." Which I have to say, these guys are such freaking snowflakes. So
Yeah.
there's Liz Cheney, but you made us feel bad, Liz. They can't, they're having a hard time coping with her.
I mean, gosh, we could have a whole show about that, about what it's the challenges of being a strong woman in American society. But there's also the gaslighting there, just that the experiences of so many people in terms of their emotions being not mattering, compassion being for losers, and all of a sudden, heads I win, tails you lose. It's really, I don't know,
Yeah.
Charlie. You can't
Yeah.
make this stuff up. You
No.
can't.
Okay, so since we're talking about the attacks on democracy, I'm really struck by the fact we talked about this briefly before you and I started this podcast, that if you turn on Fox News or you listen to conservative media, the people like Ted Cruz or Mike Lee as well, you hear all of this fustian about the need to protect free speech against the cancel culture. But here's the irony that right now, the Republican Party is waging a really aggressive two-front war against the First Amendment. I want to see whether you agree. I mean, number one, the calls to use the power of the government to retaliate against private businesses that have politically incorrect comments. To cancel Major League Baseball, for example, or the push to compel the internet platforms to carry speech that they don't want to. But then the other front, and which is even less subtle, and I really want to get your views on this. All of these bills around the country, Republican legislatures and governors moving hard to go after the rights of protesters. And they say they're anti-riot bills, but they go so far as to create protections for motorists who run into protesters. And here's the New York Times report. Republican legislators in Oklahoma and Iowa have passed bills granting immunity to drivers whose vehicles strike and injure protesters in public streets. A Republican proposal in Indiana would bar anyone convicted of unlawful assembly from holding state employment, including elected office. A Minnesota bill will prohibit those convicted of unlawful protesting from receiving student loans, unemployment benefits, or housing assistance. And in Florida, the heartthrob of the Trumpian right, Governor Ron DeSantis signed sweeping legislation this week that toughened existing laws governing public disorder and created a harsh new level of infractions, a bill he has called the strongest anti-looting, anti-rioting, pro-law enforcement piece of legislation in the country. And the New York Times is now estimating that Republican legislators in 34 states have introduced 81 anti-protest bills this year. So give me your take on this. I mean, they will claim that Now, this isn't about free speech. This isn't about the First Amendment. This is about rioters. This is about people who break the law. But the line's fuzzy, isn't it?
Yeah, what you're describing in terms of stripping people of their rights, other rights, by virtue of having been convicted of a protest-related offense. I mean, that alone just sounds like punishing people for speech. I mean, that sounds certainly not like a free and fair democracy, something a little darker in other parts of the world. I also did a piece in The Hill recently because I have a daughter in Ohio who said, "Mom, do you realize what's going on?" In Ohio, there's similarly a package of bills. One of them would empower police officers to sue people who are protesting from the sidelines if they feel, these are, I'm paraphrasing, but if they experience that as distracting. So the irony, and
What?
I know, we've talked, we can talk about qualified immunity, right?
Which I do want
I
to.
know
Yeah.
we're going to talk about the Chauvin trial. We're talking about police brutality, so much power in the hands of police. And now we're going to let police sue protesters. I mean, I thought about this morning, Charlie, and I wanted to just as, in a meta level, just to kind of clear the decks here and take a deep breath and start from basics. Quote from Justice Brandeis in 1927. He said, to explain why this is a problem, right? He said, quote, "Those who won our independence believed that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth, that without free speech and assembly, discussion would be futile. It is hazardous to discourage thought, hope, and imagination. That fear breeds repression. That repression breeds hate. That hate menaces stable government. That the path of safety lies in the opportunity to discuss freely supposed grievances and proposed remedies, and that the fitting remedy for evil counsels is good ones." This discussion is, there's nothing more important in this moment, Charlie, than this discussion. I mean, you get your kids vaccinated, you hold their hands when they cross the street, you take steps to pay attention to democracy failing in our lifetime. And that's what we're talking about here.
Yeah, and that should not be controversial. That's a very eloquent statement of what we had thought was the liberal democratic consensus in this country, at least until recently. All right, let's dive into the Chauvin verdict, because I know you have spoken and written very, very extensively about this. You had a piece in the Bulwark which really made the very provocative point that this trial, even though I think it resulted in justice, really highlighted the fact that we need to do a better job of having of trials of police officers. What did you mean? Where do we need to go?
Well, I mean, it was kind of an academic approach to the laws, right? So this is a multifaceted, complex problem that has to do with access to guns that make police feel uncomfortable, to screening police officers for narcissism and sociopathy, to putting more people in government that can address mental illness and other sort of crises in people's lives that the police aren't actually sort of trained to do. However, what my point was is that the criminal laws aren't designed to deal with people in office, right? Or people in uniform. So when you think about say Murder 2 in Minnesota, which required a showing of an assault in connection with, in this instance, in connection with something that led to a death, that can give rise to a murder conviction. Police have access to force that you and I don't. They can use chokeholds. They can put people in handcuffs. They can point guns at people's heads. If it were you and me, it'd be very easy for a jury to see the line between what's appropriate behavior and not appropriate behavior. So we're taking laws for civilians and applying them to police officers. And here, the jury is in a position of saying, okay, what's the difference between reasonable police force and a criminal use of police force? We haven't, the laws don't do that for police. Just like we saw, and I mentioned this in the piece too, like with the Trump administration, that in the Mueller report on the question of obstruction of justice, 11 incidents of obstruction that Bob Mueller identified in Volume 2. But the conservative and scholarly response to that, both, and I think it's a legitimate one. It's like, wait a minute. the president is in charge of the executive branch. The president gets to decide who's attorney general. If he's calling off an investigation, that's part of his power. When does that power get abused? And I think the laws need to be tailored to that, in addition to, qualified immunity, which I know a lot of people don't understand. That's a civil defense to money damages against police officers that was manufactured by the Supreme Court. Again, Congress needs to step in and give some definition of what's reasonable for police officers. We need disincentives in the law for them to violate some standard, some norm that is elusive for jurors. And I think that's a lot of reasons why we don't see these prosecutions and we don't see these convictions, is because the law isn't really fit to deal with reasonable use of force that regular people can't have access to.
So is that possible? Because one of the reasons I would think that the law hasn't stepped in is because it's very difficult to write a law that will deal with all of the circumstances, all of the judgment calls that have to be made. I thought one thing that was really striking was the way in which the police departments had developed their own internal rules and standards. But those, as you point out, those were not laws. But it's one thing to have the flexibility of having policies and rules. Is it possible to have laws that are not too intrusive or not too prescriptive?
Well, I think so. I mean, we have them for civilians, right? And we're just talking about them for peaceful protesters under the First Amendment. I'm not saying it would be easy. We have it for, 42 USC 1983. That is the law, the Ku Klux Klan Act that Congress passed, that gives private parties a right to sue police officers for violating their constitutional rights. And then this qualified immunity doctrine arose as a defense. And what does that mean? Well, basically, the court has said if a police officer is in a situation and doesn't know that an action would violate a constitutional right, that's not obvious to them based on the law, they can walk away and there can be no lawsuit that would move forward. So I agree. This is a tricky, thorny thing, but we could start with really basic things like, unreasonable police force is, using force when it's evident that somebody doesn't have a pulse. Like, there are certain things that we wouldn't need 3 weeks of trial and multiple expert witnesses to draw some boundaries legislatively where police know to back off. And then, in fairness to them, they have some guidelines that are really clear that protect them as well.
So let's talk about qualified immunity, because this keeps coming up again and again. Walk me through this. My understanding, which is limited, is that qualified immunity is a judge-created standard that has perhaps had some unintended consequences. So qualified immunity does not exist in statutory law. Is that correct? Is it just
that? Is just correct.
Okay. So where did it come from?
It came from a series of Supreme Court decisions. As I said, the way so. This surprises a lot of people. You can't just walk into a court and cite the Constitution and say my rights were violated. You need what's called a cause of action, where in most instances, with few exceptions under the Constitution, Congress has to say, listen, we're going to let you use the courts to enforce your rights. And as I mentioned, that's Section 1983. And that gave private parties the ability to go and sue police officers, primarily because the idea was, notwithstanding all the Reconstruction Act amendments to the Constitution, particularly in the southern states, constitutional rights were not actually being honored by government vis-a-vis primarily people of color. But then the Supreme Court said, well, it's not really fair to say to a police officer after the fact, using that kind of force was a violation of the Constitution, when that fact pattern's never come up and been addressed by a court. The court gives meaning to the Fourth Amendment, gives meaning to all these, the Fifth Amendment, the First Amendment, the Eighth Amendment. And so essentially they said they've created this test that says, unless it was clear that what the police officer would do would violate a clearly established law. That's the word, clearly established law. They can walk away and the lawsuit goes away. And so that's gotten tightened to mean almost, a decision that is on similar facts, like almost the same scenario happened before. So basically, if a police officer is breaking new ground and violating constitutional rights, whoa, no one thought of it before to violate it this way, they can say, listen, I didn't violate any clearly established right. Therefore, this isn't even just, I don't get as much money damages as I might have. This means it's a complete defense. The lawsuit gets totally dismissed. Plaintiff walks away with zero. And so I think that's part of the push to have Congress put a definition on that. Now, we've heard some states saying banning qualified immunity, but that's not going to have an impact on federal constitutional claims. That has to happen at the congressional level, not at the state legislative level.
Well, that's one of the so that actually can be addressed on a statutory basis, but you also have this larger question of, and I'm really struck by after the Derek Chauvin case, how rare it is for officers to be convicted. And I think the number was something like, 1 out of 2,000 cops that are involved in a fatal encounter. That we have created a culture, a mindset that makes holding police officers accountable for this extremely rare. I mean, it's kind of interesting in 2021 to learn that Derek Chauvin is the first white police officer ever convicted for the killing of a black person in the state of Minnesota. The very first person, and it's 2021. So this has been going on a very, very long time, and it's deeply ingrained into the culture of the criminal justice system and the police department. So I mean, that's the question: how do you unwind that? I personally think the Chauvin case might have been an interesting turning point, because I think I've said this before on the podcast. I was really struck by the extent to which that blue wall of silence came down during this trial.
Yeah, I mean, I got the sense that, when you mentioned what you're referring to is this idea that police officers testified one after another and kind of closed ranks against Derek Chauvin and said, listen, what he did is not us. And I think it was an important message to the American public that there is good policing. And I know in my piece for the Bulwark, I cited a 2013 study by the Justice Department that they surveyed whites, Hispanics, blacks, and there was no statistically significant difference in the response rates in terms of when they wanted police support, they had a good experience. I mean, people want good policing, and I think that is defunding the police or getting rid of the police. That's just not a realistic. That's not a realistic debate, and that's not the terms of the debate. But I think a couple things have happened. One videotaping, Charlie, body
Huge.
cams.
Yeah.
I mean, videos don't lie. They don't forget things. They don't misremember like a witness. So that's going to shift things. And what we've described, I mean, I think people are worried, and this runs throughout the law and the Supreme Court's decisions around qualified immunity and all these things. There's a sweet spot because most of constitutional law is a balancing act. So on the one hand, you want to say police need to be able to do their jobs. They have to be able to use the force that's necessary to keep the public safe, to investigate crimes, to all of that. On the other hand, they need a disincentive for violating standards and for abusing with that massive power they have. They have power you and I don't have to use force. And it's that sweet spot that the law is trying to get at. The problem is, as far as the disincentives, there really isn't anything there. If you couple qualified immunity with the problems in the law, and that's why I wrote the piece for the Bulwark, this idea that the criminal laws aren't really tailored for police officers. So prosecutors, like, it's close to impossible to win that case. Prosecutors only bring cases they think they can win.
Mm-hmm.
They just don't bother otherwise. And of course, there's also this blue wall of silence. So I think a lot of things are happening across the country with this. And the message to law enforcement is, wait a minute, things might shift for you. You're going, the days of impunity might be over or shorter, unless, of course, as you indicated, we have Republicans in various state legislatures empowering police and bystanders. I don't know. That's a stunning thing.
Well, the body cams work both ways as well. I mean, they not only make it easier to hold cops accountable, but somehow, sometimes they can be used to defend a police officer. Now, people might notice that we are not talking about the shooting in Columbus, Ohio right now, and that's because I am one of those who's like, hey, could we wait a little bit longer to see how the facts shake out, because that was one of those classic moments where everybody rushed to judgment. Now there's body cams out, pictures out that make the scene somewhat more ambiguous. I'm not prepared. I mean, this is one of those things where, because the stakes are so high, we ought to be cautious. That's somewhat naive given social media, but that's one of those stories where you kind of felt the narrative change when the cams came out. But again, there may be more details here. So let me ask you this about the Chauvin case. One of the questions that still lingers over it is what happens now? And what do you make of the prospects of appeal? There's some people who are saying, well, the Maxine Waters comments or Joe Biden's comments might be grounds for an appellate court to throw out the verdict. What do you think?
Well, I mean, grounds for an appeal are different from a basis for reversing the verdict. So, there will be an appeal, and there's going to be a number of issues on appeal, including that they didn't sequester the jury because there was a motion for that earlier, including that they didn't move venue to get it out of Minneapolis, including comments that the defense lawyers objected to by prosecutor Jerry Blackwell, saying that they were biased, potentially biasing the jury. I think the Maxine Waters argument is not going to fly anywhere. I mean, the notion that after 3 weeks of testimony, the jurors who are they were directed to not pay attention to the news, unless there's some proof that they did pay attention to the news, the law treats it as if the jurors followed the instructions of the judge. And the notion that they'd somehow listen to a member of Congress rather than the 3 weeks of testimony they had just slogged through, to me, that's just not realistic. I mean, Charlie, what's amazing about this trial and this conversation really is the facts of this case. And I told my students, like, this is a moment to feel good, separating the race piece. I mean, I think that's important. But this is a moment to feel good about the American judicial system, because the facts and the law carried the day here. It wasn't about politics. And why? Because even if in the beginning of the video, he was acting off, right? So many police officers pedestrians might watch that and say, okay, George Floyd was potentially menacing. He was acting a little odd. They took steps to manage the situation. When he no longer had a pulse, there was no version of reasonable use of force after that. Zero. And even the defense lawyer's top, expert on cause of death said that, or actually, I'm sorry, it was on reasonable use of police force, said that as a physician, he thought it was a mistake to not give him medical attention in that moment. There was no, you know what I'm saying? There was no alternative version after he lost his pulse. And I think that is what's going to carry the day on appeal.
So you mentioned one thing that's been nagging at the back of my mind as I watch this: the decision not to sequester the jury. If there was ever a case that would call for sequestration, it would seem to be something like this. So what was your take and your reaction to the judge's decision not to sequester the jury?
It's expensive to sequester the jury. It's really trying on their families. So I wasn't that. I mean, it's unusual. So, but what's interesting is that he didn't do that, but at the same time made the comment about, how politicians shouldn't be talking. And I thought that was, the jury probably heard that. So yeah. I don't know. I mean, the judge is in a tough spot. That's a really hard job. Prosecutors, defense lawyers, it's really easy to second guess those decisions. I think they all overall did very, very professional jobs in this trial. And again, I think this is a moment, setting aside race, which is, I'm not denying, is a really, really big problem in policing. But this is a moment where the American justice system worked. And what I point out to my students, Charlie, is that unlike politicians, unlike cable news, Tucker Carlson, Ron Johnson, all these people, the lies, the big lie, the January 6th, courts are bound by rules. They're bound by evidentiary rules, procedural rules. So it doesn't matter what your politics are when you get in court. Judges can't color outside the lines around politics and ideology, or they get whooped by the appellate court. Lawyers can't color outside the lines; they get whooped by the judge. And to me, that in this cacophony of bad information and lies, it's like a place to exhale. And I thought that it's a good thing for Americans to strive for across our public discourse.
No, I think the exhaling does describe, I think, the reaction here. The problem is that juries can be They can be crazy. Juries can engage in nullification. And the juries, are drawn from the pool of American citizens, and to the extent to which Americans no longer are fact based, could potentially impact some of these decisions. But you're absolutely right. This was good news. Okay, let's switch back to democracy for a moment, because you've written very extensively on voting rights and on elections. Let's talk about HR 1, the status of HR 1. I see today that the Congressional Black Caucus is saying, hey, maybe we ought to shift our focus to the John Lewis bill, which is more narrowly focused on voting rights, particularly involving African Americans, as opposed to HR 1, which is sprawling and goes on for hundreds of pages and doesn't seem to be going anywhere right now. So give me your sense of that, because I personally have thought it was inevitable that sooner or later the attention was going to come back to the John Lewis bill, because I'm not necessarily optimistic, but that's a much harder no vote for some Republicans. Doesn't mean they won't do it, but I do think it's a harder no vote. Your thoughts?
Well, given what we talked about at the top of the show, that it looks like the Republican strategy for staying in power is to sort of strong arm their way and not necessarily do it based on issues. I'm a little skeptical that any version of national legislation that's going to increase access to the polls for people is going to be palatable to the Republican Party, particularly given that, as last check, the Brennan Center for Justice had 250 plus bills across the country to suppress the vote. That being said, the HR 1 does include also stuff around campaign finance, and that's a really tricky issue, and that's different from common sense reforms to increase access to the ballot, and then of course the Shelby County versus Holder 2013 part of the Voting Rights Act, that is something the Supreme Court sent back to the Congress to fix. And just for the listeners who don't know that piece, essentially, the statute was passed in the 1960s because, notwithstanding the 15th Amendment that gave African American males a right to vote, and that some states were doing what we're talking about now, these suppression efforts, and get literacy tests, things like that, and even counting the number of bubbles in a bar of soap to basically manufacture justifications to keep people from the polls. And so Congress passed a statute saying, listen, if before you get cute and change your rules, you've got to run it by DOJ.
Right.
And that worked tremendously well until the Supreme Court struck it down in 2013. Justice Ginsburg famously dissented and said, it's like saying, my umbrella is working so well in this rainstorm, so I'm going to throw my umbrella out. It was working really, really well. And so that piece does need to be put back in place. But again, Charlie, all of this stuff, I just think the writing's on the wall that we're in a pitched battle for we the people deciding our own electors, with one party saying, I don't want people deciding, and the other party still committed to democratic values. And I mean that, democratic Republican values, like the constitutional values, not party values. So I'm skeptical anything will get passed without either killing the filibuster or doing it through, or amending the filibuster or doing it through appropriations, where the Democrats only need a bare majority.
So I know this is repetitive for listeners of the podcast, but I just want to remind people that when the Voting Rights Act was originally passed back in 1965, it was passed with an overwhelming bipartisan vote. One of the co-sponsors was the Republican Senate leader, Everett Dirksen. When it was reauthorized during the Bush years, I think the vote was unanimous, and it was signed by a Republican president, George Bush. And yet here we are with it being very unclear whether there will be much, if any, Republican support for restoring voting rights and the John Lewis bill. My only question about the John Lewis bill is whether or not it could be made to apply to all the states rather than just the southern states.
Well, I haven't studied the sort of details on how they're amending the formula, but under the original act, basically there was a formula that was applied to decide which states are bad actor states. And it wasn't just southern states. I mean, there were northern states as
Mm.
well, and that were basically, based on the statistics, were determined to be out of whack in terms of access to the polls for certain communities. And after 1965, I mean, the numbers of African Americans, just surged in these states actually having access to the ballot. So even the conservatives on the court in Shelby County said, listen, this is a spectacularly successful piece of legislation, which, as you mentioned, passed multiple Congresses, not just once, but multiple reenactments by Congresses and bipartisans in the votes in the high 90s. So, I mean, what's interesting to me about this discussion, and I know we don't probably have time for it, is to talk about the United States Supreme Court and the fact that the court stepped in and silenced the legislature in that regard, and a lot of what we're talking about here, protests, First Amendment stuff, voting rights, all of this is going to go to 5 people that are unelected and are there for life on the U.S. Supreme Court to basically decide. And I'm really hoping that conservative principles carry the day with this court, because, conservative jurists tend to say, listen, stuff should be done in Congress. It should be the people that vote. It should be the people that decide. And so it really sticks in my craw when the Supreme Court jumps in and on shady, or I should say shaky, not shady, shaky ground strikes down an act of Congress that had such bipartisan support for so many years.
And you kind of wonder whether or not the Chief Justice might be having second thoughts about the role that he played in that. You'd like to think so, maybe?
Yeah, I mean, the Chief Justice, it seems that he, they made a bunch of mistakes. They made a mistake with Citizens United in allowing unlimited money. I read recently that a huge proportion of money that's in politics are from like a handful of billionaires in America on both sides of the political spectrum. I mean, it's really amazing. And that is giving corporations First Amendment rights in Citizens United. There were no corporations when the Constitution was ratified. So the notion that these fictions that are clicks of a mouse now, they're not even actual pieces of paper. They're like leprechauns, legal leprechauns that are created to minimize liability, that they have First Amendment rights, like living, breathing people. I mean, it defies logic from a very conservative textualist, originalist standpoint. But I agree with you, Charlie. I think he's worried about the Supreme Court's legacy. He's worried about the Supreme Court's legitimacy, and he should be. Mitch McConnell really did a tap dance on that with the 3 justices that are now sitting with not any Democratic support. That's Gorsuch, Kavanaugh, and Amy Coney Barrett. I think that's corroded and eroded the institution, and so a lot is riding on these justices to not step outside their limited role going forward and get people upset. And represent all Americans, Charlie.
Well, and there is all of this talk about court packing. I personally don't think that it's going anywhere. I think that the Democratic leadership does not want to do that. I don't think Joe Biden wants to do it. However, there is a commission. So it is sort of like they've taken out the gun and they've put it on the table. It may not be loaded, but it's there. So does that focus the minds of the justices? Are they looking over their shoulder, thinking that, this threat's out there? I mean, I remember the famous story from the 1930s, of course, when Franklin Roosevelt tried to pack the court, he failed spectacularly, but the court then began to rule in a rather different way after that. And of course, there's a lot of people who believe that the court was responding to that threat. So what do you think? Do you think it'll have?
Yeah. So just to get for an example, so, FDR comes in and he does a New Deal, lots of legislation, an expansion of the administrative state, regulators, which now a lot of people really resent. And the Supreme Court started striking down a lot of that legislation on these old kind of arcane doctrines, like saying, for example, agencies shouldn't be passing regulations. That's for Congress. It's known as the non-delegation doctrine.
Mm-hmm.
So there was like one historian likened it to a Shakespearean tragedy, right? Where everyone gets killed by the end, and the dead people on the stage were the New Deal programs. And then with this court packing threat, they did back off. And we haven't seen that kind of use of these doctrines since the 1930s. Like non-delegation, for example, has been brought up and up and up. And even a conservative court has said, no, we're not going to touch agencies. So that's possible. But I also just wonder, though, Charlie, with the midterms coming up and this election and the Democrats holding both houses by a a thread of a thread of a thread, that even having a court packing commission could bring people out to vote, to shift the House and or the Senate to the Republican side of the aisle, which would be a huge price to pay for a shot across the bow to four justices on the Supreme Court, if we include Justice Roberts as really kind of a moderate at this point.
Kim Wehle, thank you so much for joining me. You can find Kim's books, What You Need to Know About Voting and Why, and How to Read the Constitution and Why. They're both in paperback. Kim, always great to have you on the podcast.
Oh, always great to be here. And I have a new one coming out, Charlie, in February, How to Think Like a Lawyer and Why, so we can keep this conversation going.
You got a theme there going, don't you?
Yes. Yes. Think for yourselves, friends. That's the deal. Don't listen to me.
I'm thinking about the pattern, the whole, and why you'd want to do this, because
that's it, right, Charlie? If you understand the why, you understand the what, and you get to make the decisions for yourself and not listen to people like you and me as much as we like to talk.
It's funny you should mention that. I mean, that I bring that up because there was once a time in my life when I was sort of addicted to asking the question, why? When somebody would say like, well, why would I want to do that, or why? And as I thought of it as just kind of an opening to get deeper into an issue, and I would find out whether or not somebody had really thought something through. But what I found was that a lot of people found it very challenging to be asked, why? Why would I want to do that? And I'm afraid I went through a number of friendships by asking questions like that.
Did you drive your parents crazy too? We all know that, right? The kid's like, why?
Oh, well, of course.
Why do I need to go to bed at 8:00?
But see, my parents and I, we were into debating and arguing about stuff like that all the time. So that was okay. What I found was that when I left home and tried the same tactics with civilians, it did not always work.
I mean, Charlie, even in law school, I've had students that feel silence. They're worried that if they ask the hard questions, they'll be judged, they'll be ostracized, they'll be canceled, or whatever the words are. And we just have to be open-minded and tolerant with each other as we learn. So I do think the and why is a critical
I think so.
Step towards, maybe in all this darkness we've been talking about, maybe finding some light that will shine on democracy. If we can have real conversations about real issues where we tolerate people's need to learn.
Well, if people are worried about those invisible tripwires, try this. This is an interesting tool, just to say, Mr. Teacher, why? Why should I think this? Why are you saying that? Without committing yourself, but just requiring them to elucidate and maybe reveal whether or not they have any idea what they're talking about. Kim Wehle, again, thanks for joining me on the podcast, and thank you all for listening to today's Bulwark podcast. I'm Charlie Sykes. We will be back tomorrow, and we'll do this all over again.